Assalamualaikum and good day. I bid to Sir Amir Falik. We are from Group 5 and we will be presenting the first assignment.
Before we start, allow me to introduce our group members. Firstly, I'm Shafika with metric number 273306, Nur Farhana with metric number 264742, Siti Aisha Zulaika with metric number 270347.
Next, Tiva Nathan with metric number 271927, Zinira with metric number 267918, and lastly, Nur Aina Kamila with metric number 268097.
My name is Anshafika binti Abdurrahman with metric number 273306, and I will be explaining the facts of the case of Eng Hitung and another against Public Bank Berhad 1995. This case basically it revolves around summary judgment. In this case, the appellants are guarantors for the loan advance to Fu Yin Sdn Berhad. The liability of the appellants under both guarantees is predicated upon the making of a demand made by the respondent to the appellant. Upon default in paying the loan by the debtor, the respondent sent a letter of demand of the said payment to the appellant. However, the letter was sent to a different address rather than the one stated in the loan guarantee, which in the loan guarantee is stated that the appellant's address was situated at 83 Jalan Sultan Iskandar Ipoh. As the respondent did not receive any response from the appellants, the respondent proceeded with an action against the appellants and obtained judgment in default of non-appearance of the appellants. The appellants then took up a summons to set aside the default judgments entered against them on alleged ground that they never received the letter of demand from the respondent. On February 15, 1993, the court set aside the default judgment against each appellant and they then delivered their defense to the action on February 25, 1993. On May 11, 1994, that is to say after a lapse of 15 months, almost 15 months after the last proceeding in the case, the respondent took out a summons for judgment. However, no explanation regarding the delay was provided by the respondent. Thus, the appellants opposed the summons by way of an affidavit, which they asserted that they had not received any demand from the respondent. They also alluded that the judgment in default has been set aside. The respondent in this case still fails to provide explanation nor file any affidavit in answer to the allegation made by the appellants. The respondent also did not produce any affirmative proof that letters of demand has been served to appellants by simply exhibiting the AR card as evidence of receipt. Therefore, after several considerations, the court held that the appellant's affirmative declaration on this crucial issue remains uncontested because the respondent did not provide any justification for why it addressed the letters of demand to addresses other than the ones specified in the guarantee. The demand issue cannot be decided in a summons for judgment. It must be decided at the trial of the case. The appellants are therefore permitted to rely on the respondent's failure to meet the deadline specified in Order 3 Rule 6 of the Rules of the High Court. In an application for summary judgment, a defendant is entitled to raise any and all procedural objection to deny the plaintiff's application. The plaintiff also should have explained the delay via affidavit before the other side raised the issue according to the proper procedure that the trial judge should have accepted but did not. In this instance, the reply gave no justification for the delay. Therefore, the appeal was allowed by the court. Next, there are two issues that can be found in this case, which are the first issue is whether there was a triable issue, which indicates in this case the issue of whether a demand had been made by the respondent, and the second issue is with regards to the correct procedure to be adopted in determining the issue of a plaintiff delay in prosecuting an application for summary judgment, and this will be further explained by my other group mates. So I will pass to the next presenter.
I will explain about the provision in the case of Eng Hitong and another versus Public Bank 1995. To begin, a summary judgment is a ruling made by a court without a full trial in favour of one party against another. Under Order 14, Rule 1, Subsection 1 of the Rules of Court 2012, a plaintiff may, after the defendant enters into appearance, apply to the court for an order for summary judgment against the defendant. This is by relying on the ground that the defendant has no defense to a claim of any damages. Secondly, the court shall carry out its obligation under Order 14, where the question at hand is entirely one of law and makes no reference to any facts, or where the facts are unambiguous and plain. The court, however, may award a summary judgment if the legal argument is clear and the court is certain that it is beyond a dispute. Under Order 3, Rule 6 of the High Court 1980 stated that in the event that the proceeding has been ongoing for a year or longer, the party intended to continue it must give the another party 1 month's notice. In the case of Bank Negara Malaysia versus Muhammad Ismail 1992, the guiding concept for applying for summary judgment is demonstrated. Because there were no tribal issue in this case, the appellant entered judgment against the respondent after being persuaded by the affidavit evidence. This is because when one party asserts a fact and the other dispute, it is in affidavit. The judge ruled in Order 14 application does not apply. This is demonstrated in the case of China Insurance Co Limited versus Yong Ahlan 1973, when the plaintiff gave notice of trial roughly 23 months after the delivery of the defense did not provide notice. The accused made a request to invalidate the trial notice. However, the plaintiff admitted during argument that a month's notice should have been given out, but did not submit any affidavits to explain the reason for delay in submitting the notice of trial. The irregularity with regard to the failure to provide notice under Order 3, Rule 6 is small, and to deny this application on that basis will only serve to stall the matter.
The first issue is whether there had been a triable issue. A summary judgment, although formulated for cost and time efficiency, shall not be determined whimsically. Order 14 must only be exercised where the entitlement of the judgment on the part of the plaintiff is certain and shall not be implemented where it will deprive the defendant's right to give evidence. Hence why, in order to proceed with a summary judgment, it is vital to ensure that the defendant could not possibly raise any defense against the claim. Where defense can be raised, summary judgment should not be resorted, as it does not apply to complicated cases or cases that have tribal issues. It must be understood that tribal issues are matters that the court could not determine in the absence of the hearing of parties. Since summary judgment aims to skip the litigation process straight to its judgment, it would be unjust not to hear what the parties may have to say in order to succeed in their case. It is to be noted that a summary judgment can only be applied where the substantial issues or essence of the material facts are clear and undoubted by either party. In other words, the object of dispute shall not be the question of fact or the question of law. Rather, the dispute can only be on, for example, to whom is a right entitled or who has the better title. If the defense could raise a tribal issue, he may use it as a defense to interdict the summary judgment. This case can be illustrated in Uniphone Telecommunication Berhad against Bridgecon Engineering Sedihan Berhad and another, where the summary judgment was stopped as the court held that there were bona fide tribal issues. In this case, a judgment was enforced against the appellants for failing to appear to the respondent's writ. In response, the appellants issued a summons to nullify the judgment and attach an affidavit of support to argue that they had not been served with any notice of demand. The appellants are clearly challenging the respondent on the facts of whether there had been proper service of notice of demand by the respondent. The matter in dispute by the appellants is the question of fact. However, the respondent had defaulted to serve any affidavit in answer to the assertion. Later, it was found that the respondent had served the notice to different postal addresses than as provided by the guarantees. After the judgment has been set aside, it took the respondent a lengthy period of time to take out another summons. However, their affidavit had disregarded to provide any clarification in regards to sending the notice to the wrong address. In deciding this case, the judge took into consideration all facts and stated that the respondent had clearly defaulted in serving the notice to the correct address. It would be unjust if the summary judgment was decided when the appellants could raise a question of fact available to be used as defense on matters that should be heard in a trial. The appellants had challenged the respondent on the matter, but the respondent stayed silent instead of contradicting it. Thus, the judge followed the governing principle that assumes the respondent's admission of the evidence as asserted. In other words, it is safe to assume that the respondent admitted to the facts as provided by the appellants. Therefore, the appellants could use the matter of service of notice of demand as a defense against a summary judgment, and the case is no longer suitable to be decided under a summary judgment, but rather more appropriate to be determined in a trial. In addition, in Alloy Automotive Sdn Bhd against Perusahaan Ironfield Sdn Bhd, it is alluded that a single tribal issue would suffice to bring the case to be heard in a trial. The second issue is with regards to the correct procedure to be adopted in determining the issue of a plaintiff's delay in prosecuting an application for summary judgment. The judge in this case affirmed in reference with the English common law practice that it is the defendant's rightful position to use any possible procedural objections in order to go against the plaintiff's summons. Order 3, Rule 6 stated that if a party wishes to pursue a proceeding from which the last motion has exceeded 1 year, the party must notify every other party of minimum a month's notice. However, as mentioned above, the respondent in this case had been silent after the judgment has been set aside, specifically for a period of 1 year and 3 months. The judge also highlighted the practice in the bar to take oath upon any matter adduced as evidence in which the previous judicial commissioner had failed to uphold. As the appellants had asserted under oath on the excessive delay on the part of the respondent, it is the respondent's legal responsibility to reply by way of affidavit to elucidate on the reasons for the delay. After acquiring the explanation, it would be the court's discretion to decide on whether the delay is reasonable or not, relying on the different facts of each case. However, failure on the part of the respondent to justify the delay on oath has shown that it is fatal to the respondent's case, once and for all as it contributed to the final decision of the court to allow the appeal.
As a conclusion, based on this case, in assessing whether there are triable issues in the case, it is necessary for the respondent to provide for an explanation to be served to the court on the said issue. This is because failure of respondent to provide explanation that there were issues to be tried will cause the statement from the appellants to be uncontested. For instance, it can be seen from this case that since the respondents did not serve evidence with regards to the legitimacy of the delivery of the letter of demand, the appellant's argument that they did not receive the letters remain uncontested. Next, in determining the issue of delay in the plaintiff's prosecution of summary judgment, the court shall adopt the procedure by which explanation can be made by way of an affidavit produced by the plaintiff himself. It was necessary also for the plaintiff to file the affidavit in support of his summons for judgment. With that, we finish with the first case and we proceed to another case. Thank you.
Now, I will continue with the review of the second case, which is the case of United Merchant Finance Berhad against Majlis Agama Islam Negeri Johor, 1999, Current Law Journal, page 151. In this case, the respondent had placed 1 million ringgit Malaysia as a fixed deposit with the appellant's Batu Pahat branch and was given 2 fixed deposit receipts identified by receipt number 209431 and 209451. The respondent subsequently demanded for the refund of the money, but the appellant failed to comply. The respondent then filed a lawsuit against the appellant for the deposit sum together with the interest, pleading that the appellant owed the respondent the refund of money under the fixed deposit receipts. And the respondent also claimed that the appellants were liable for that since they are the constructive trustees. However, the appellant then submitted their defense in which they claimed that the fixed deposit receipts were issued fraudulently or not properly authorized. This case is regarding an appeal brought by the appellants to the Federal Court based on the decision of the Court of Appeal, where the Court of Appeal had granted the appeal of the respondent and summary judgment had been entered for them. It has been decided contrary to the decision at the High Court, where since there is bona fide triable issue established by the appellant, where the case was a complicated case, the issue of constructive trustee and fraud were substantive legal issues, and there was a third-party notice issued by the appellants on MUI Continental Insurance Sdn Bhd seeking an indemnity against the respondent claim. So the summary judgment cannot be given to the respondent. This appeal being brought by the appellant because they argued that the decision of the Court of Appeal is error since the judge in Court of Appeal concluded that the defense by the appellant was only a bare denial, and the judge also did not consider the tribal issue being brought by the appellant, which is the constructive trustee, even though at the Court of Appeal all of the parties already had knowledge regarding the criminal case involving the respondent former president, in which both the one 1 million deposit and the fixed deposit receipt had featured in evidence. Therefore, based on the decision of the Court of Appeal, there are some issues arise which need to be solved in the Federal Court, which are whether there was some other reason to be a trial within the meaning of Order 14 Rule 3 Rules of the High Court 1980, and whether the court has discretion to grant leave to the appellant to defend in absence of any of the triable issue being brought by them in the High Court previously.
I will be explaining on the provision and cases. In this case, the highlight is on the application of summary judgment. A summary judgment is an application to the court for an early judgment and to dispose the civil case at a faster rate. However, the application can only be made for certain cases, in which depends on whether the defendant has no triable issues in his defense, which constitutes a lack of a need for a full trial. The proceeding of a full trial could render a delayed judgment. The details on the application of summary judgment is provided under Order 14 of the Rules of Court 2012. Based on Order 14, Rule 2 of the Rules of Court 2012, the provision explains that in the circumstance where the defendant has no defense to a claim, the plaintiff can apply to the court for an early judgment against the defendant to be made. In the current case, the Federal Court referred to Order 14, Rule 3, Subsection 1 of the Rules of Court 2012, which explains that the court shall allow summary judgment to the plaintiff if the court is satisfied that there is no issue of question in dispute which ought to be tried, or that there is no other reason to be a trial on the claim. The court will not allow the application of summary judgment if there is a triable issue in the claim. The court referred to the case of Miles against Bull. The case explains that the application to a summary judgment would be dismissed if the defense is satisfy the court that there ought to some reason for trial. Another case mentioned in the federal court is the case of Concentrate Engineering against United Malaysian Banking Corp. The case explained that there was a reason for trial, thus the application for summary judgment was dismissed. In the appeal in the federal court, the circumstance points that it constitutes some other reason to be trial, which is in accordance to Order 14, Rule 3, Subsection 1 of the Rules of Court 2012. The defense was able to satisfy the court that there was a triable issue in this claim. Thus, the federal court set aside the application of the summary judgment.
On this analysis part for the first issue whether there was some other reasons to be trial within the meaning of Order 14 Rule 3 of the High Court 1918, the burden to prove there are issues that need to be tried before the court is on United Merchant Finance that appellants in order for the summary judgment not to be awarded to the Majlis Agama Islam Negeri Johor, which is the respondents. In this case, the High Court dismissed the summary judgment on the ground that the appellant established bona fide triable issue to defeat the respondent's application in summary judgment. Same rule applied in the case of Southeast Asia Insurance Berhad versus Kerajaan Malaysia, where the court held that if the defendant in an Order 14 application succeeds in raising a triable issue, it would not be proper for a summary judgment to be awarded. Hence, the respondent appealed this current case to the Court of Appeal. The Court of Appeal found that the appellants had not raised any credible defense to enable them to defend the respondent's claim. Notwithstanding, the appellant then obtained leave to appeal to the federal court. Hence, there are the reasons on constructive trustees and also fraud issues which constitute some other reasons to be trial, which fall under Order 14 Rule 3, where tribal issues have been established by the appellant at this stage. As to the second issue, whether the court has restriction to grant leave to the defendant in the absence of tribal issues, the appellant claim under Order 14 of the Rule of Court is based on fraud and also the constructive trustee issue. The court allowed the appeal with the cause and granted the appellant unconditional leave to defend since there are some circumstances which constitute some other reasons to be trial, which consists of issue of constructive trustees, where the appellant denied the deposit amount for and on behalf of the respondent. Therefore, the plaintiff has to prove their claim. Secondly, the issue of fraud, where the evidence, which is the two fixed deposit receipts that were the focus of the claim, were identical exhibits in a criminal case involving the conviction and also the punishment of the Majlis Agama Islam Negeri Johor's respondent, former president, who was charged with criminal breach of trust in relation to RM1 million.
In conclusion, to apply for summary judgment, there are some conditions that need to be fulfilled first. One of the conditions is that there are no triable issues which may arise, since with the triable issue, summary judgment cannot be given. As in this case, it was held that the federal court had allowed the appellant's appeal and the order from the Court of Appeal had been set aside by this court on the reason that there is tribal issue like issues on the constructive trustee and some other tribal issue within the meaning of Order 14 Rule 3 Rules of the High Court 1980 that need to be determined in a full trial. Therefore, no summary judgment should be given to the respondent. Plus, the court also held to give the appellant unconditional leave to defend the action. It shows here that the federal court totally has discretion to grant leave to appellant to defend, even though in absence of any of the triable issue has been brought by them in the High Court previously. Since there already are the triable issue that falls within the meanings of Order 14 Rule 3 Rules of the High Court 1980. It also shows that the defense being brought by the appellant is not a sham defense but one that is prima facie which raising serious triable issue that is bona fide that the court can grant the unconditional leave to them.
With that, we conclude our presentation for today. Thank you for the interest and attention and also for your time for listening to our presentation. Thank you so much.